No cruel or unusual punishments. A person's punishment should match their crime. Through the 14th Amendment's Due Process Clause, the 8th Amendment ban on cruel and unusual punishments gets pulled into state law, making sure states have to play the same fairness rules as the federal government. Hear ye, hear ye. On this day, 1850, the 8th Amendment will be enacted.
I'm a born U.S. American.
Hey man, you gotta go to work!
Look out, grenade!
Yeah, no, I'm out of here.
The next day.
Where's that really weak looking man though?
Hey, so I kind of escaped yesterday, but we're cool, right?
Oh hell nah! You get 3 years apart later and you get dishonorable discharge.
Oh!
Day is never finished. Master got me working. Someday Master set me free. Dude, shut up!
An eternity later.
Hey, can I apply for a passport real quick? Sorry, what? I can't apply for a passport because my citizenship was revoked? I'm suing all of you guys! Fun fact, a relative legislation was the Nationality Act of 1940 that states a citizen would lose their nationality if dishonorably discharged. But in 1952, it was superseded by the Immigration and Nationality Act. Too late for Albert Trump now.
Help me, please.
Citizenship is not a license that expires upon misbehavior. This is a cruel and unusual punishment. The court rules in favor of the defendant.
The court held that stripping a native-born citizen of their citizenship as a punishment for wartime desertion was unconstitutional. This ruling established that the meaning of cruel and unusual evolves with societal standards of decency.
Officer,
You look suspicious. Let me see your arm.
I'm just trying to walk over here, officer. I'm not trying to do anything.
Try forward.
Those are mosquito bites from camping.
California Health and Safety Code say being an addict is illegal. Welcome to 1960 California.
Silence in the court. Mr. Robinson, you've been accused of a heinous crime of being sick.
Your Honor, they're clearly lying. You can tell they're guilty because they have an addiction. You can see it in their arm right there.
Those are mosquito bites. The jury has to deliberate for about 30 seconds. You're guilty. There's no jury over here. You're sentenced to 90 days in jail. You know what? This is a cruel and unusual punishment. The 8th Amendment protects me from this nonsense. The 8th Amendment only applies to the federal government, not the California government. We'll see about that. I'm taking this to the Supreme Court.
The Supreme Court has reached a decision. We rule in favor of Robinson. You cannot punish someone just for being sick.
Yes! Freedom!
Oh, freedom!
Making it a crime to be an addict is like making it a crime to have a cold. Addiction is not an illness, not a criminal act. This violates the 8th Amendment.
Before Robinson versus California in 1962, the 8th Amendment only restricted the federal government. Through the 14th Amendment's Due Process Clause, this case incorporated the 8th Amendment and made it apply to all 50 states. This is called the Incorporation Doctrine.
Right.
One eternity later.
I sentence you to death.
I appeal to the sentence and conviction.
The Supreme Court.
What you did was not cruel and unusual punishment. We will uphold the death penalty.
structure this case to prevent arbitrary and capricious application, states must now follow specific procedures like bifurcated trials, where there are separated proceedings to determine guilt and then to decide on punishment.
Okay, so these people went to court, right? But there's gotta be other ways for them to fight these punishments.
Well, instead of suing, they could have just lobbied state legislatures or tell Congress to change the law directly or join an interest group.
Oh, kind of like how California eventually repealed those laws and made addiction a crime?
But legislation can take years. Sometimes court cases are faster. Number 2, state constitutional provisions. Some state laws have even more protections than the U.S. Constitution does.
Robinson could have argued that California Constitution have cruel and unusual punishment clause.
But the rule only applies to California, not all 50 states.
Number 3, Civil Rights Act. If a punishment discriminates based on race, disability, or other protected class,
You can sue under the American Civil Rights Act and or the Americans Disabilities Act.
Addiction could be treated as a disability under these acts, which means this could have been used for California versus Robinson.
4, habeas corpus petition. This is actually how most 8th Amendment challenge starts.
Habeas corpus means shows me the body, basically proving that you have the legal authority to hold me.
prisoners petition this in federal court to challenge a detention or a sentence.
But those cases from the 1900s. What about right now?
Let's check what Supreme Court have been up to from the 2021 to the 2024.
Jones v. Mississippi 2021, the court ruled that judges can sentence juveniles to life without parole.
Wait, I thought you couldn't do that.
If the judge considers a juvenile's youth and other factors, they can't make it mandatory, but they can allow it.
But here's a win. Nance versus Ward 2022. Death row inmates can sue under civil rights law to propose alternative execution methods.
Like if they think lethal injection is cruel, they can argue for a different method.
The
8th Amendment is still being defined today.
Alright, so we've covered a lot. What's the big takeaway in all of this?
The 8th Amendment protects us from punishment that are excessive, disproportionate, and inhumane.
The definition of cruel and unusual punishment isn't frozen in time, but it evolves with society.
In the 1700s, public hangings and whippings were normal. Today, we debate whether or not lethal injection drugs are too painful.
So what society thinks is acceptable is how the Constitution is now interpreted?
How does the 8th Amendment protect people today?
Death row inmate challenge execution method and procedure.
Prisoners sue over horrible conditions, including overcrowding, overheating, and even lack of medical care.
Juveniles sentenced to life without parole appeal their sentences.
People in solitary confinement for decades argue it's psychological torture.
People unable to pay their bail challenge excessive bail amounts in court.
And remember, without the 14th Amendment in corporate doctrine,
The 8th Amendment would only apply to the federal government.
Robinson v. California was the first case to incorporate it to the states.
So now, every level of government, federal, state, and local, must respect the ban on cruel and unusual punishments.
But here's the thing. Who decides what's actually cruel and unusual?
the Supreme Court, right?
Yes, but they don't decide in a vacuum.
They look at evolving standards of decency. Basically, what does society think?
They look at state laws, public opinion polls, jury verdicts, and international practices.
So in a way, we, the regular people, help shape what the 8th Amendment means.
The 8th Amendment is just 16 words.
Well, those 16 words have protected over millions of people over 230 plus years.